Hello, everyone. Last week, the Supreme Court delivered a very important judgment in the case relating to Maharashtra's political crisis. The judgment delivered by a constitution bench has laid down very important points of law regarding the powers of Speaker, the application of the anti-defection law under the 10th schedule, the powers of the governor, and also various other important constitutional issues. Although the Supreme Court held that the Maharashtra governor as well as the Maharashtra Assembly Speaker, they took many wrong decisions. The court did not grant ultimate relief to the Uddhav Thackeray faction, saying that he resigned without facing the floor test. So the judgment lays down a lot of important issues, a lot of important points. So today we have with us an expert on parliamentary law, Mr. PDT Achary. He was the former Secretary General of Sabha. Welcome, sir.
Thank you.
This is the third or fourth interview we are having with Mr. Achary on the very same Shiv Sena crisis, on Maharashtra political crisis. So it is very interesting to note that the Supreme Court's judgment has endorsed several views expressed earlier by Mr. Achary. In an earlier interview with us, he had said that the decision in Nabam Rabia, that should be reviewed by a larger bench because it's the proposition laid down in Nabam Rabia has a great potential for mischief. And in the Supreme Court, in the Shiv Sena case, the Supreme Court has said that Nabam Rabia should be reviewed by a larger bench because certain propositions are very debatable, and a reference has been made. Supreme Court has also said that, similar to what Mr. Achary said earlier in an interview with us, that the test of legislative majority used by the Election Commission to determine who is the real Shiv Sena, that may not be a very appropriate test. The Supreme Court has made an observation to that effect. The court has also said that the ECI's declaration will have only prospective effect, which was also an opinion expressed by Mr. Achary earlier. So, sir, the court has laid down several points of law, and very important points of law when we think from the perspective of federalism and also the importance of parliamentary democracy. But ultimately, the court did not grant relief to Mr. Uddhav Thackeray. And maybe technically the court is right. Since a person resigned voluntarily, the court cannot quash that resignation. That's what the court said. But do you think that on a larger perspective, the court should have done more, having held that all previous decisions, such as the Speaker's recognition of the Shinde group, the governor's decision to call for the floor test, all these decisions were wrong decisions. All these decisions were unconstitutional decisions. That's what the court held. And these decisions led to Mr. Thackeray's ultimate decision. So do you think that the court should have thought in a different line in this case?
Well, I would say that the court should have given a very decisive kind of judgment on the basic issue. The basic issue in this is who was authorized to issue the whip. The whole issue, according to me, hinges on who has the authority to issue a legally valid whip. That issue has not been decisively determined by the court. That, according to me, is a major flaw in this judgment. Otherwise, they have said so many right things. Why do I say this? The point is, the court has said only the political party can issue whip. To that section, the court is absolutely right. That has been my point as well. I have written articles earlier emphasizing this point, that it is the political party that issues whip. It is the political party that appoints the chief whip. So it is basically the political party which takes the decision on these matters. That position has been made clear by the Supreme Court. But then after that, what? You have the court has referred the matter back to the Speaker. The question of disqualification of these members. That is the most important, or that is the core issue in the whole thing. Both, as we know that both the groups have issued whips to all the members. So whose whip is valid? and whose whip is not valid. That is a question which the court should have decided with a finality. That has not been done. It has been left to the speaker. Now, the speaker, what will the speaker decide? As per the anti-defection law, the speaker has to decide whether members against whom the petition has been filed have defected. That means either they have voted against the whip in this particular case, that is the most important thing. That is, they defied the whip and voted against it. Another point that was a part of the earlier petition was some of them have voluntarily given up the membership of the house, membership of the party. Now, these are the two grounds on which a person can be disqualified. A sitting member can be disqualified. But here, because so many things happened in the assembly, voting was taken and all that. So now the whole issue hinges on how many people and who are these people against whom the petition has been filed, whether they have defied the whip issued by the original political party. When the court says whip can be issued only by the political party. But after that, where was the need for the court to leave it to the speaker? Because the 10th schedule makes it very clear. If you look at the explanation to paragraph 2(1), you will find that the as candidates is the original political party. So the law helps you find which is the original political party and how the political linkage or affiliation to a party could be decided. You don't have to go any other source. The law is very clear on that. It is the party which sets them up as candidates, puts them up as candidates, is the political party to which they belong. So all these members against whom the defection charges have been made, they all belong to the party which set them up as candidates in the election. And that party is the party which is called Sena, which was headed by Mr. Uddhav Thackeray. And he is the person who signed the whole thing, the candidature and all that. So it is not very difficult for the court to find that this is the original political party. Now, it has been sent to the speaker, and speaker has been asked to find out which is the political party which could issue the whip. That is a thing which should have been decided by the court, because that is to be decided in accordance with the law. That is the thing. After that, yes, when you decide that it is the Shiv Sena which had the authority to issue a whip, then think. But here, the Supreme Court has made certain formulations which are, according to me, are not very correct. One is that the court says that when a party splits, two factions arise which are not the party, which are different from the party. Now, these formulations do not square with the scheme of anti-defection law. First of all, there is no split recognized by the anti-defection law. I mean, as it exists today, there was a provision for split, but that was a kind of a defense. 1/3 of the members can move out if there is a split in the original party and all that kind of thing. That doesn't exist now. That's been deleted, and that is no longer applicable. So there is no split under the anti-defection law. So how can the court make this proposition that the party splits, two factions arise, and then it is for the speaker to decide which faction is the party? It is certainly not the function of the speaker to decide which faction is the party. See, the point that we must understand is that the anti-defection law, as it exists today, does not recognize any kind of faction. It doesn't speak about any faction.
One interruption. So when the court says that the whip appointed by the whip recognized by the speaker, who was appointed by Mr. Shinde, that was not the proper whip. That decision was illegal. The court has actually made a declaration that the appointment of Mr. Gogawale as the whip, who was nominated by the Shinde group, that is illegal. So when that declaration is made, the consequence is that the whip backed by the Uddhav Thackeray group is the real whip. So if his instructions are violated, then the consequences of anti-defection law will flow. So the court has made the declaration, and the speaker has to decide in the light of the court's declaration. So,
but then the court, says so many other things that the speaker will have to go into the constitution. So when you say that two factions exist, the court has said two factions exist. They are not a party. And then the court says that, and then the speaker has to find out which faction is the party, which faction could. So all these things do not tally with each other. Though
so you're saying that if the so-called split happens, there is only the original political party and the breakaway faction. It's not like
that is not. There is actually not even a faction. So far as anti-defection law is concerned, we must understand that it doesn't conceive of a faction or anything. That was there when the split provision was there. Now the split provision is not there. Therefore, there is no question of faction being recognized by the anti-defection law.
No, not legally recognized faction, but factually there is a breakaway faction who are liable to be disqualified. That's what you're saying.
Okay, it may be. But the point is that for the purpose of anti-defection law, there is an original political party from which people have defected. That is the thing. It's a simple thing. They have defected. Now, in this kind of a situation, when you sit down to decide who could issue the whip, when both the groups issued whips to all the members, naturally that question arises: who can issue the whip? Whose whip is valid? So when you sit down to decide that issue, then you have to go to the explanation that is there in section in paragraph 2.1. As I said, it is very simple. The party which put them up as candidates in the election, that is the party. And therefore, there is no ambiguity there. There is no confusion. When that is so, I don't know why the court has said that the speaker has to look into the constitution. The speaker has to see whether the constitution has been added to, amended unilaterally, all that kind of thing. According to me, these things have no relevance so far as decision on a question of disqualification arises. That is what I was trying to say in my article also, that it creates a lot of confusion there.
So you are saying it's a very straightforward case for deciding that there was one original party as per the explanation to paragraph 2, and there is a rebel group who has broken away and who has attracted, and since split is no longer recognized as a defense, and since they have not merged with another party, so they are liable to be disqualified. So it's very clear from the facts. So
yeah, let me make it more clear.
That's what you're saying, right?
Let me make it more clear. On the one side, you have the original political party. On the other side, there is a group of MLAs. There are MLAs who have defied the whip issued by the original political party. Now you decide. It is as simple as that. They have defied the whip. Whether they belong to a group or faction or whatever, that is immaterial so far as anti-defection law is concerned. First of all, it doesn't recognize any faction.
In the election, they had voted for the rival candidate.
Yes.
That record was there before the court.
Yes. So this is the position. MLAs, a certain number of MLAs, 35, 36, 37, or whatever number, those MLAs have defied the whip issued by the original political party. But the Supreme Court says only the original party can issue the whip. To that extent, they are absolutely correct. But after that, you have to find out which is the original political party as per the anti-defection law. And there, go to the explanation to 2.1, you will find that it is the party led by Mr. Uddhav Thackeray, because that is the party which set them up as candidates in the election. That is the thing. That is what I was trying to say in my article today.
But since the court must have thought that Speaker is the constitutional authority as who has to decide the 10th schedule matter in the first place, the court must have thought that we should not interfere into the Speaker's decision-making process and we should leave to the Speaker.
Well, the Speaker decides. Nobody is disputing that. The Speaker is the authority who will decide these things in the first instance. There's no doubt about it. Supreme Court is right when it says that the Speaker has to decide it first. Only after that, when it comes to us, we will look into it. But the Speaker has to decide it in the first instance. That is okay. But then if you tell the Speaker that you have to look into the Constitution, you have to look into the fact whether there has been an addition to the Constitution, or party Constitution, not Indian Constitution.
Yes,
the party Constitution. Party Constitution, whether it has been unilaterally amended, altered, or things like that. All these things, these are all, according to me, these are all extraneous things so far as the anti-defection law is concerned. And Speaker is normally not interested with this kind of a job. That is the thing. Speaker has to merely go by what is written in the 10th schedule. And he has there, Speaker is not called upon to decide which faction is the party and so on.
So essentially you are saying that the court's observations that there are two rival groups and it has to be determined who is the real party. These observations have complicated the situation before the Speaker in what was otherwise a very simple and straightforward case. That
absolutely. Right. That is precisely what I have been saying.
Now, sir, now coming to the other aspect. So now the court has held that the governor was wrong in calling for a floor test. The governor had no objective material before him to decide, to make a decision that the government had lost confidence. And the court had also commented that the governor was entering into the political arena and he was trying to settle the intra-party disputes, and which is not permissible for a constitutional authority. So after making all these declarations, the court ultimately did not grant relief to the Uddhav Thackeray group. Court refused to reinstate or restore his government. So do you think that was there any other way possible for the court to do that?
Well, you see, there are certain aspects of this matter which need to be considered. One is that the court says the governor was absolutely wrong and it was an illegal act on the part of the governor to have asked the Chief Minister, that Uddhav Thackeray, to take a floor test. Court is very clear on that. It was wrong on the part of the governor. It was illegal and all that. It is outside the law. This is what the court says. So it is an illegal exercise of power by the governor. But then the court stops when it finds that Mr. Uddhav Thackeray has resigned before taking the floor test. So the entire exercise has become infructuous. It will have no consequence at all. This is what the court says. Otherwise, they could have reinstated him. But since he resigned voluntarily, court will not intervene and court will not reinstate him. This is the position which they have made very clear. Of course, it is logically correct. But then, looking at the other actions which followed, the governor asked one of the members of the ruling party, that is Sena, whose chief minister has resigned, to form a government. When the court says the governor has no business to interfere in intra-party or inter-party disputes, governor should stay away from all this, it's the constitutional authority and all that, then it becomes very clear that the governor was taking sides and he was very much involving himself in the inter-party disputes. When he called one person who was a breakaway person, he broke away from the main party, and this governor, by calling him, was actually exposing himself to the charge that he is actually involved in the inter-party disputes. So governor was taking sides here, which was absolutely wrong as per this as per the Supreme Court itself. Supreme Court says a constitutional authority cannot involve himself in inter-party disputes. But that is precisely what he was doing. Then what exactly are you supposed to do? Now the court, Supreme Court, this is the Supreme Court of Justice. It has to do justice in a matter. So there has to be a consideration of these things. It is not that you say
just
it's not enough.
So you're saying that the governor should have invited since the Uddhav Thackeray government resigned, the governor should have looked for the next alternative. That is, who is the next largest party, which is the BJP. So if the governor had given an invitation to BJP, that would have been right. That's what you're saying. But since governor invited one rebel faction who is not legally recognized, since invitation was given to that breakaway faction who might have been exposed to disqualification or due to defection, you're saying that the governor overstepped his authority, and governor was committing the same error or the same mistake which the Supreme Court said the governor made when he called for a floor test for the Uddhav Thackeray government.
Absolutely. So he was actually committing the mistakes which the Supreme Court said he should not. The governor means getting involved in the inter-party disputes and conflicts and all that. So by calling him, the governor was exposing himself to this charge. So how does the Supreme Court look at it? It doesn't look at it at all. That is my grouse, Supreme Court actually does not look at this aspect at all. It simply brushes everything aside and says that the governor had a responsibility to form to invite somebody to form a government, and etc., etc. These are all theoretically right, but looking at the factual situation that emerged there, then perhaps the Supreme Court would have looked at it and given an opinion on that, or formulated an opinion on that, whether calling Mr. Eknath Shinde was right or not. That question has not been answered by the Supreme Court, which was a very important question in this context.
So in effect, which you can say that the Supreme Court was letting the parties who had committed the wrongs, the constitutional wrongs, to reap the benefits of their own wrongs, to enjoy the fruits of their own activities, illegalities.
As I use this expression in the article, enjoying the fruits of illegality.
Right. Now, the Supreme Court has also said that the Election Commission's decision that will only operate prospectively. That clarity has been given in the judgment. And the court has also made some observations to the effect that the Election Commission was perhaps wrong in, court did not explicitly say that, but court said that the test of legislative majority may not have been proper in the present case. And the court has also made observations regarding whether parties, members who are facing disqualification proceedings, whether they can participate in House proceedings and vote proceedings. And the court has said that they can, because the declaration of disqualification, that will also operate only prospectively. So how do you, what is your take on these declarations made by the court?
Yes, actually, there are one or two things which I wanted to discuss. One is that the Election Commission was allowed by the Supreme Court to decide this issue, and the Election Commission decided it in rather haste, and said that Eknath Shinde is the party, or his faction is the party. And the Supreme Court has not agreed with that and said that he has already looked at the legislative majority, but there are many other factors which should be taken into account for deciding this issue. That's okay. But then Supreme Court has not decisively said that the Election Commission decision, of course it said it will have prospective application and all that, but it did not decisively say that the decision of the Election Commission is set aside or something. Of course, I know
pending challenge, another matter.
There is a case pending in there. So now there is a confusion whether the ECI's decision stands or not. There is a little confusion. Because some people think that since there is no decisive Supreme Court did not strike it down, or Supreme Court did not say that this decision doesn't stand. Such an opinion is there now. So there is a little confusion on that score. But then, of course, we know that this case is pending before the court, so naturally the Supreme Court will take a decision on that issue. But here, in the meantime, what exactly is the position with regard to the status of Shinde's faction? Whether it is, because there are so many things which need to be done by a party. Whether Shinde's faction is the Shiv Sena or not at the moment, at this moment of what exactly is the position? Nobody knows. There is lack of clarity on this aspect. Either the Supreme Court should have said that this matter, since it is the subject matter of a case which is pending before us, so we will take a decision on merit later. On that case, in that case. Till then, the status quo will remain. But that also they did not say. So what exactly is the position? On that, there is a little confusion. That is. Then there was another thing. The Supreme Court said that even if members are disqualified, they remain in the party. They are not expelled by the party. So that is a very mystifying kind of observation by the court. When the members are disqualified from the house, but they remain in the party and they are not expelled. Actually, it is very difficult to understand what they were saying, the meaning of that observation. When a person, one of the grounds on which a person is disqualified is, or sought to be disqualified is, that he has voluntarily given up the membership of that party. So once he is disqualified on that ground, can you say that he remains a member of that party? It's something which I don't understand. That is the thing. Disqualification comes after.
Perhaps
after he voluntarily gives up the membership.
What the court might have meant was there is no automatic termination of political parties' membership. There has to be a separate action by the party leadership.
That is not necessary to. It is not necessary to say such thing, because a person is sought to be disqualified when he voluntarily gives up the membership of the party, and the speaker gives a finding that he has voluntarily given up the membership of the party. And after that, if you say that although he has been disqualified from the house, he remains a member of that party, how do these things square with each other? I don't really understand. And that observation is still, sort of bothering me, because I'm not able to understand the meaning of that observation and the relevance of that observation in this context.
Right. So now, before we wind up, the final comment. So who do you think won in the case? Which side the judgment is ultimately favoring? Because the judgment is very it can be interpreted in many different ways.
That exactly is the problem. Who has won and who has lost? Nobody knows. And that is the beauty of this judgment. So each side thinks that it is winning, or it is the winner. And who will decide now? It has been left to the speaker. And speaker, they already, that Shinde faction has already said, or Shinde party has already said, that we are the party, we have issued whip, our whip is legitimate. So we have issued a legitimate whip, so all those people should be disqualified. This is the problem that will arise when you don't decisively determine the issue.
So ultimately, it's for the people to decide in the elections. I believe
that is the ultimate thing. That is the ultimate thing. But you have to decide things in accordance with the law. So what is the consequence? What is the consequence of an action like defection? That will be decided in accordance with the law of defection. That is it. People ultimately will decide whatever. That's a different issue. But we are dealing with the law and how the law is operationalized. That's it.
So, all right, sir. Thank you so much for sharing your views on this topic. Thank you so much.
Okay, welcome.
Thank you.